have City Prosecutor Gary Hersey to present the first three items up first. And I don't know, if, Gary, if you want to do all three together, or do you want to do them individually?
Whatever works best for y'all. These are the three items are not directly related.
Okay.
So
the first up will be ordinance adding section 9A 24-230 to the BMC entitled Open Carry of Weapons Prohibited in Municipal Buildings. Mr. Hersey, take it away.
All right. Well, thank you all for having me and letting me go first too. This is exciting. But basically, the first suggested change to the code is to adopt this particular RCW, which pertains to the open carrying of weapons on, for our purposes, municipal buildings. This would make it unlawful for any person to knowingly open carry a firearm or any other weapon while knowingly being in a location such as a Norm Dix building, or in the event that City Council were to hold meetings in another location, such as the conference center or Gold Mountain, some other city property. It would be unlawful to openly carry so long as you're not law enforcement or military engaged in active duty, at the time, or otherwise a valid CPL holder. What this statute would require is just for signs to be posted at the locations. So this would be posting signs, essentially notifying everyone, putting them on notice that this is a prohibited location in Washington state. Otherwise, generally speaking, Washington law doesn't generally prohibit the open carry of firearms and weapons in public locations unless otherwise prohibited. So this is an RCW that was recently enacted and passed by the state legislature this past session and went into effect. I think it was this year, I think maybe June or so. And we had been contacted by risk management asking about whether what the city would have to do to adopt this and put this into effect. So that's why we're bringing this one to you, and I'm happy to answer any and all questions you may have.
All right, thank you. President Chamberlain.
Thank you. And so this did come to public safety. We did vet it, approve it. It looks like we're just updating it to go in line with Washington State Legislature. And I just want to make sure that I understand correctly. You said it excludes military, active duty while they're at work, police, and then you said you gave an acronym. Was that the concealed weapons permit?
Oh, sorry. Yeah, concealed pistol license is the
okay
full name. Yep.
And this excludes. Let me ask, for instance, a machete, right? Like that would be also excluded from or included in this open carry ban, correct?
Yes. So weapon is broadly defined in another location in RCWs. It means any firearm, explosive, any weapon of any kind, such as a slingshot, sand club, metal knuckles, knife, dagger, dirk, or similar weapon that is capable of causing death or bodily injury. So it's a pretty broad definition, but that has been tried and tested for some time, that definition, under challenges to, Second Amendment challenges, things of that nature. That's been the definition for some time.
And, a lot of people, like including my son, carry around like, a little pocket knife, utility knife. Is there a definition of the length of knife that somebody can carry that constitutes a weapon?
That's a really good question. I think technically that could count as a weapon if it's capable of causing death or bodily injury. A lot of times that's the kind of thing that would go to a jury if it was put in front of a jury and say, does this qualify as a weapon? So it kind of depends on the facts of each case. But that being said, it often comes down to prosecutor discretion whether you would ever file under those circumstances. And here, I think the aim of the legislature is to make sure simply that open governing bodies can do their job without fear of intimidation and potential violence at hotly contested public meetings. So that's why we're bringing this one here.
Thank
Hopefully not to harass small children.
Well, he's not very small. He's 18 and he's taller than me. But he's been carrying a little knife around since he was about 16. So it's pretty standard thing. I just had that lingering question that I forgot to ask in public safety. I'll sign off for now. That's all my questions and comments.
Thank you. Denise.
I just want to say I really appreciate this. I really appreciate staff taking this on and becoming aware of it and taking it on and getting it through. I was the one that had asked if it pertained to all city-owned buildings and like the conference center and Gold Mountain. I have a question. Did we consult at all with Columbia Hospitality as to their how they feel about us posting? I know it's our property, but was there anything from that standpoint that came up?
I can't say that. I don't know if we did. Kylie, do you know?
We didn't consult with Columbia Hospitality. I know that Gary did have a conversation with Mike Riley today about posting on the building, but the other issue is that we do have to affirmatively take the steps to post. Gary and I talked about that. We see this as being an issue that we pursue whenever a meeting is in progress. And so it might not be something that we have the signs out there where a meeting is all the time. It might be something that we put them up if we think that we need to. So
that's great. Thank you for that. That really good thinking on that.
Is that your take on that, Gary?
Yeah, I think, the way the RCW is written is, I think it applies to the primary building. So in our case, the Norm Dix Government Center, but in the event that there was another applicable meeting to go to any number of other buildings, they don't have to be owned by the city necessarily. Then at that point, as long as a sign is posted, then it applies only at the times when the sign is posted and the meeting is ongoing. So that doesn't make the conference center off limits forever, just as an example.
Understood.
All the meetings going on.
I did see that the city of Kelso had adopted it, and there was a news article, and they were looking at whether it would be applicable, because the first council meeting after it was going to be enacted was in a park, and whether it was applicable there. Gary and I talked about that situation, and I think it does talk about buildings rather than just spaces. So just to give you some ideas to think about there.
Thank you.
Hey, Jeff.
It's actually perfect. One of my questions was about quorum, if we're all meeting at a festival or event. So it sounds like if we're outside, that's okay. But if we do choose to meet in an indoor space, then this would go into effect.
Well, it's only if we have the sign up too. So like if you all decided to, let's say, attend something like AWC conference down in Olympia or something like that. Just because this ordinance is on the books, we don't have to, of course, follow you around with signs. It could mean that, maybe that if you read the actual bill, there's a lot of protections in this legislation for the state capitol as well. So if it was that particular example, you'd probably be covered under someone else's sign. But this is really about what signs we're going to be putting up in our buildings, and then us being able to pursue charges if the signs are violated.
Okay, that's great. So we don't have to put up a sign and enforce it if it's an iffy situation. Okay.
Sure. Yeah. So if the sign's not up and there's an issue, then we aren't going to be able to pursue charges in that situation.
Okay. Perfect. And then I was looking at the current the BMC 98.24.220. So if I understand right, this would add section 230. But we have 220 on the books currently for, I think it's more concealed carry, or just weapons in general. And that one I noticed specifically exempts security personnel while engaged in official duties. And if I'm reading the RCW right, the RCW just seems to exempt law enforcement and military personnel. So I'm wondering if we enacted this, and let's say, I hope we don't have to, but let's say for some reason we wanted down the road to hire a private security personnel who was carrying, would this then prohibit us from being able to do that?
That's a good question. I guess if the private security person has a CPL themselves, they would probably be exempt from this. And I can see that the 220 was a code that was written rather than adopted. So that's something that could always be revisited. But I think they might be covered under the CPL exception. I would imagine most security people would have a CPL, but I don't know.
Okay, so if we ever did want to go that route, we would just might need to come back and update this code to just keep that in mind.
I
Okay.
think so. That's a good question. I would need to look into it.
Okay. Yeah, I don't think it's a showstopper. I just wanted to make sure that was out there. And again, heaven forbid we don't have to do that, but in case we need to. Last question I had, just so I'm clear, I guess right now, even though it's state law, BPD can't enforce it, and by putting it on our BMC books, it lets BPD enforce it. Do I have that right?
So yes. Oh, sorry. Go ahead, Kylie.
No, I was just gonna say, it's not BPD, it's our office, Gary and Amanda really, and our municipal court. So when a Bremerton police officer responds to a call, and if the referral needs to be for an offense that we have not adopted, or that you have not adopted, and that we can't prosecute it. We can only prosecute under the authority of the Bremerton Municipal Code. And so those referrals, they're just as much illegal, but they go to district court and they get prosecuted by Chad Enright's office, the county prosecutor, and heard by district court judges sitting in Kitsap County in Port Orchard. So this allows us to handle these locally with our own prosecutors and our own municipal court.
Okay, that makes a lot of sense.
Right. And in this particular case, because it involves some affirmative conduct on our part to put up signs, it's even more likely that I would be very surprised if you saw any prosecutions in a municipality that had not adopted this, right? Because they would have, if they haven't adopted it, they're not going to be the ones putting up the signs. So.
Okay, got that. Clears it up. Thank you. That's it for me.
Thank you. Quinn.
Thank you. Thanks, Gary, for the work on this. Thanks for presenting it to public safety already. I was just going to respond to Jennifer's question. I noticed in the RCW, it specifically states that a knife that contains a spring, detent, or other mechanism designed to create a bias towards closure of the blade that requires physical exertion applied to the blade by hand, wrist, or arm to overcome the bias toward closure to assist in opening the knife is not a spring blade knife. So I think because the legislature specifically calls out spring blades and defines what that is and carves out possibly pocket knives being part of it, I think most likely pocket knives would be fine, but I don't know what the case law says on that. I just wanted to throw that in there for you guys.
Thank you. Okay, so to be clear on this, this is coming from Olympia, and it's to reduce open carry in municipal buildings when meetings are happening, when government meetings are convening. Is that a good summary on this?
More or less, yes. It can apply to buildings, and particular buildings on the whole. It includes a number of state capitol grounds, which obviously don't apply here. But then I think the idea is that should meetings happen anywhere else, it will be a protection there. Should the city, town, county, whatever, choose to put up signs and put people on notice.
Okay, so like for instance, if we do have a retreat at Gold Mountain, we're afforded that, and I assume that's the most we can sort of get away with, as you know, we can't restrict open carry sort of more than that, I assume is what the issue is. Okay.
Yep.
All right. Are we okay with consent on this? It's really kind of housekeeping. It's coming from Olympia. There's, you know, it's interesting, but okay. I'm seeing some folks. I think we're going to do consent on this. So, and then just as a reminder, Jennifer Chamberlain will be chairing next week's meeting. So, all right, up next is the ordinance amending sections 9A 32070 and 9A 32080 of the BMC entitled Domestic Violence, state statutes adopted by reference, and order for protection and restraining order, state statutes adopted by reference, respectively.
All right, so the next agenda item is the result of some pretty broad sweeping changes to protection orders in Washington State that affected a number of laws pertaining to how civil protection orders are petitioned for and penalties for violating those orders, and that's where it affected the BMC. So what I'm asking to do is to amend these two codes to reflect the changes in the RCWs as a result of this engrossed substitute House bill. I think it was 1901 was the number. So it made a number of changes. Essentially what this legislation did is it deleted a whole bunch of chapters and consolidated them into a brand new chapter. Because as a brand new chapter, we obviously didn't have the foresight to predict where it would go. What the changes to the code that I'm suggesting are deleting the now defunct chapters that are no longer in place. That's 2650 RCW, as well as 1014 RCW, and also adopting chapter 7.105, which includes the penalties for violations of protection orders and violation of anti-harassment orders. These are really, really common crimes that we see in Bremerton. So this is something we've always prosecuted in the past. We're not asking to do anything new. We're just asking to make these changes so we can continue prosecuting when people violate protection orders and anti-harassment orders.
Great, thanks. And again, this is housekeeping. This is, adopting what Olympia is telling us to follow. Denise. Oh, we can't hear you.
Kudos to any advocacy groups that you were working with or got this information, from. Important changes ongoing around domestic violence, and really appreciate the city moving forward on this. Thank you.
Jennifer.
Once again, already came through public safety. We've edited, approved, and this is just once again, they're still prosecuting these crimes. This is just a matter of semantics and coming up to par with legislature. That's all.
Anna.
Just adding my voice to say very happy about this. Very glad that we are mirroring the state's decision. Thank you.
All right, folks, how would you like to treat this? Is that okay on consent? All right, thank you. Next, ordinance adding sections 9A44130 and 9A44140 to the BMC entitled Interference with a Healthcare Facility and Penalty, respectively.
All right, thank you. So this is my last item. We had been contacted by Legal Voice, a nonprofit. I think it might be nationwide, but at least they have an office in Seattle, if not. Essentially what this is an RCW that's actually been on the book since 1993. This makes it unlawful for any person to basically recklessly, willfully interfere with access to healthcare facilities, most commonly seen in abortion facilities. After the Roe v. Wade decision was overturned with the Dobbs case by the Supreme Court, we were contacted by a nonprofit advising us of this RCW and encouraging us to adopt it. We brought this to public safety a couple weeks ago just to let them know that we think it'd be a good idea to adopt it. For what it's worth, thankfully, I have not seen a single referral like this. Sometimes I'll receive referrals for charges from law enforcement, and then I go to look it up and I'm like, oh, we actually don't have it adopted, and I have to send it over to district court. Fortunately here, that is not the case. I've never seen one of these, but this might be a good thing to adopt just in case we were to start seeing something of this nature. And this would apply to all sorts of facilities. It's not just for abortions or anything like that, but anyone who is willfully obstructing with people getting access to healthcare beyond, which exceeds beyond, First Amendment free speech rights, it might be something that council would like to adopt. So we wanted to bring this to the council.
All right, thank you. Council? Jennifer?
And yeah, you already mentioned it came through public safety. And I'm assuming this also, I mean, like any kind of healthcare. So we're talking other, gender affirming care, end of life care, things that are legal and in our state. And so I just like big props to this, to the legal team for bringing this to us. This means that if there's a crime that is committed, which like you said, luckily there hasn't been that you know of, but we can prosecute it in the city limits rather than deferring it to the county, right? Am I correct with that assumption?
Absolutely.
All right. Thank you very much. That's all.
Anna?
Thanks. I'm very happy about this. And I do think that though there may not have been instances in the past, that as more and more states are making abortion virtually impossible, that we will see more visitors from out of state for this purpose. So thank you very much, Mr. Hersey, Ms. Fennell.
All right. All right, I don't see any other questions. How would we like to treat this? Consent? All right, consent it is. Thank you. Thank you, Mr. Hersey.
Thank you all.
Public Works Project Manager Katie Ketterer is here to present item 4, contract modification agreement number 3 with Rice Fergus Miller